afternoon. My name is Oliver Westmoreland. I am an OSC registered Level 3 immigration advisor and consultant with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today I'm going to talk about Judicial Review Pre-Action Protocol. It sounds rather technical, doesn't it? A simpler way of describing it is Judicial Review Letter Before Action. It means the same thing, really. I think before I explain what Judicial Review Pre-Action Protocol, which is commonly abbreviated to JRPAP, I better explain what Judicial Review is. Judicial Review is like an appeal. It's like an appeal before the first tier immigration tribunal, but it's different. If your spouse visa is refused, your working visa is refused, your student visa is refused, probably you have the right of appeal to the first tier immigration tribunal to challenge the refusal decision. This is called a statutory appeal. Some types of application do not have any right of appeal. Well, not usually anyway. Exceptionally they could, but typically they don't. Visitor visa, if it's refused, there is no right of appeal. You have to find another way of challenging it. If your visa application is refused, you go for administrative review. Administrative review is unsuccessful. There is no right of appeal. This applies to working visas, study visas, so on and so forth. There is no right of appeal anyway. There is the right to administrative review, which is a relatively unsatisfactory procedure carried out by the Home Office itself, i.e. the body who made the original refusal decision. If this is unsuccessful, you have the onward right of challenge of judicial review. So judicial review fits in where there is no right of appeal. So in a way it's like an appeal, but as I said, it's different. Appeal is a big job, a big piece of work. It's held, well, it can be done on paper, but most people prefer to have it done in person before the tribunal, which is in the UK or somewhere in the UK. You have an immigration judge, you have yourself, the appellant, you might have witnesses, you might have a lawyer. The Home Office should have a lawyer if they bother to turn up. It's a big affair, oral evidence and so on and so forth. The immigration judge examines the decision pretty much going back to basics. Is the decision really correct, going back to basics? Or does the appellant or their lawyer, do they challenge it and say, no, going back to basics, the refusal is incorrect. They used the wrong law, or they used the right law, but they interpreted it incorrectly. The judge might take loads and loads of evidence and make a careful decision, hopefully. Judicial review is different in several ways. First of all, appeal will be in almost every case before the first tier immigration tribunal. There are a few strange exceptions, but in almost every case, first tier immigration tribunal. Judicial review is held before the upper immigration tribunal, occasionally before the High Court. So the court is different. One major difference is that you have to get permission for judicial review. If you're not happy with your visa refusal, you can just say to the Home Office, I'm appealing. This is appalling. I've been unfairly treated. You send the appeal to the tribunal, they accept the appeal. Hopefully, if it's in time, you have the right, a statutory right to appeal against a decision that you don't agree with. Judicial review is a bit different. You need permission. If permission is refused, it might not happen. You can appeal against refusal of permission, but it still might not happen. So you need permission for judicial review. You don't need permission for an appeal. An appeal, you automatically have the right. The remedy for judicial review is different. If you're successful in your appeal, immigration judge says the Home Office got it wrong, UKVI got it wrong, this person is entitled to their visa, I hereby direct you to give this person their visa. Home Office could challenge the decision, but if they don't, it happens. It's a bit like that. Immigration judge can direct the Home Office or the UKVI to grant the visa, which they said was mistakenly and incorrectly refused. Judicial review is a bit different, and I want to read something from a very, very recent case just happened to see it. There were two student visas, Mr. Anwar and Mr. Shah. This was nothing to do with you, Mr. Shah, was it?
I think not.
No, he denies it. All right, we'll take his word for it. They were on student visas in the UK. They were allowed to work 20 hours per week, but they were a bit naughty. They worked for more. Unfortunately, the Home Office made a raid on the place of employment. They discovered with quite strong and compelling evidence that they had been working more than 20 hours. They were in breach of their conditions. Home Office, as is typical, they curtailed leave and said, I'm sorry, we're going to remove you from the UK. Home Office are very strict about this. In case you didn't know, don't ever be tempted to go over by a few hours on your student visa. It's really, really not worth it, and you never know when you're going to get raided. Now, both the people were interviewed by the Home Office at the workplace, and they pretty much admitted that they were working too long. They pretty much came up with it. They didn't try to fight it, but they tried to fight it in, probably advised by very clever lawyers like us. They challenged the decision on different grounds. Their answers in the interview had been misinterpreted. Now, one of them had an interpreter and one of them didn't. So there you go. The interviewing officer was rude. God, surely not. During the questioning, the officers failed to contact their employers to verify the information provided. However, this actually went before the High Court. The reason that it went before the High Court was that there was a challenge against unlawful detention that directed it to the High Court, not to the upper tribunal. The court dismissed each argument. They said each argument was not good, not strong. The Home Office's decision was supported by very good evidence. So the judicial review claim was unsuccessful. I want to read these words. Very, very interesting. This explains the really difficult thing to understand about judicial review as opposed to appeal, but I hope this will make it clear. Whether the admissions made by the students are in fact true is not the issue before me, says the judge. Whether they were a safe and proper basis for the decisions to cancel the claimant's leave is the issue. I am perfectly satisfied that they were, and these decisions were lawful. Now, this is a bit difficult and complicated. Let's go back. High Court judge wasn't saying it's not for me to decide whether they were breaching their conditions or not. It's for me to decide whether the decisions that they had been breaching the conditions were good and sound and properly reasoned. If they were, then the test is satisfied. The decisions weren't so bad that they were illogical or irrational. And this really explains the difference between judicial review and appeal decision. Appeal decision, let's put it in a quick, shorthand way. Appeal is about, was the decision right or wrong? Was it good or bad? Was it fair? Was it unfair? Judicial review is something very similar, but the way that lawyers will always put it and the way that this judge puts it, it's not about whether the decision has merit. It's not about whether the decision was good or bad. It's about whether the way that the decision was taken was correct and fair and lawful and rational. If it was, then the test is satisfied. This is something quite difficult point. You might want to think about it and send us an email if you want clarification. But that is the difference. Judicial review is based on a very simple issue. Was the decision correctly taken? Was it fair? Not is a decision right, but was it correctly taken? Now, of course, if it was correctly taken, it's probably going to be right, isn't it? Let's face it. That is the difference. So judicial review is a much narrower process. And let me tell you one awful fact about judicial review. You could win your judicial review case either before the upper tribunal or the High Court. The court will send the decision back to the Home Office or the UKVI and tell them to make a fresh decision. They say that the decision taken was not proper, it was not legal, perhaps it was irrational. That doesn't mean that they're going to make a better decision. It means they're going to make a new decision, but the visa application could still be refused, but on different and better grounds. This isn't just something you read in textbooks. I mean, you would read it in textbooks, but I know clients who've been so upset, they thought they had succeeded in their judicial review claim, and then they said, oh no, they refused it on something else. And say, why didn't they think about that in the first place? I said, yeah, fair point, but it does happen. Appeal is not really like that. If you win your appeal, the only way that the appeal can be overturned is with a proper challenge to the upper tribunal. So in those ways, appeal and judicial review are different. Now, you might think I've been droning on about judicial review, and you're right. Judicial review pre-action protocol, let me put this to you in a simple way, or letter before action. It's a detailed threat which is made to the Home Office or the UKIMMIGRATION that you are going to challenge the decision by judicial review, and you ask the Home Office to reassess the decision, and you point out why you say that the decision was not right. You point out to say why the decision was unlawful, why it was irrational, bearing closely in mind, of course, the difference between an appeal and judicial review. This is what it is. You, or very possibly your lawyer, write this letter. Could be quite a detailed letter of a few pages. It sets out the case, it explains the case, it explains the background, it explains what happened, it explains where we say the error comes, and very important, don't forget this, if you're a lawyer or indeed a normal person, put at the end the remedy you're seeking. Don't say, oh, this was rubbish, not enough. The remedy you're seeking is that the decision is examined, reassessed in the light of your representations. If you're lucky, the JRPAP will be successful. The Home Office will withdraw the decision. They will reconsider the decision. Now, again, they might reconsider the decision and come up with the same result, either for similar reasons or different reasons. So it's all a bit dodgy, but JRPAP can be successful. If it's a very weak decision, can be very successful, and a lot less trouble than an appeal. You send your JRPAP by email to the Home Office. Within probably 2-3 weeks, you're going to get a decision. So JRPAP is good and bad compared to appeal. Sometimes you've got no choice. Sometimes there is no right to appeal. You've got to engage with JRPAP because there is nothing else. I think, Mr. Shah, I can see that you look as though you've got some questions. You're busily writing there.
Yes, I do. Thank you so much for explaining JRPAP. Is it compulsory for the applicant to have a lawyer to represent for the PAP or PAP and JR proceedings?
No, but let me tell you something. This is quite difficult legal work. Average normal person might not have the legal skills to do it effectively. A lot of people think they have because they did O-level law, but you need very good legal skills. If you're an OSC firm, you can only do this work if you're a level 3 firm. Level 1, level 2 firm can't do it. It has that level of difficulty, similar to an appeal.
Brilliant. But what could one choose to do the PAP themselves and engage a lawyer at a JR stage?
Yeah, but only if it's successful.
True. All right, perfect. And could you please elaborate if there are any costs involved from the court side when lodging the PAP or JR?
JRPAP, there are no costs. This is something between you and the Home Office. Now, of course, when you get into judicial review, then there are costs, sometimes very big, but JRPAP, there are no costs. If your JRP is unsuccessful, and it's unsuccessful in a strong sort of way, you might think it's not worth, I'm not going to fight, and you haven't spent any money apart from probably your fees for your lawyer.
Sure. And is this correct that that whoever may lose in the judicial review proceedings at the court has or may have to bear the cost of the other party?
Yeah, it might be losers' costs. That's the general rule in civil litigation generally. If you lose the case, you might have to pay other parties' costs. It's not an absolute rule, but it tends to be what happens.
Sure.
But if you win, then you get your costs awarded. So you've got to look on the bright side.
Yes, that is nice, isn't it? And are there any processing time frames that the court or the Home Office must need to adhere by for the pre-action protocol response, perhaps?
Well, they're supposed to respond within 14 days, but they don't. But I think normally they would respond within 3 or 4 weeks in practice. There's not much point in chasing it up because by the time they answer, they probably would have done it anyway. They're reasonably efficient with the response to JRPAP.
Sure. And for example, if there was a joint application, let's say a family of 3 people applying for a visit visa, which was refused, and leading on to pre-action protocol, do they need to lodge a separate PAP for each applicant?
No, you can combine all the family members into one JRPAP.
Okay.
make a lot more sense, because each refusal is probably relying on pretty similar facts and being much more efficient.
True. Perfect. I think that sums up the questions that I had, and I thank you for your time, and
You're
we
welcome.
see you in the next vlog.
Yes, have a nice day.
Take care.